just a question, because I'm reading the bill and it says specifically except as required by federal law. And so as my understanding is nothing can be implemented if it violates federal law. And so I'm confused as why you think it would be a violation of the Fourth Amendment and the 15th Amendment are certainly federal law. And if,
no, could you, I'm sorry.
well, I'm just in the bill it specifically says that the board, the governing board of an institution of higher education shall ensure that each academic or administrative unit of an institution that lists these things, but the first thing it says, does not accept as required by federal law. So in other words, as I'm reading the bill, it specifically says you have to remove these programs or remove these offices, but you can't do anything that violates federal law. And of course, obviously the Fourth and the 15th Amendment are part of that.
I think
so it looks like it has a protection in it that says, you know, you cannot violate the federal law in enacting any of this statute. So I guess that's why I was having confusion why you would think that would be a result.
I think we were looking for, so two things. One, to be responsive to the suggestion that the existence of diversity, equity, and inclusion programs and initiatives itself is a violation of the Civil Rights Act, which was stated several times earlier in this hearing. So this is to, one, clarify that that is incorrect. And secondly, the proposal itself, I think the introduction of language that says that as long as it doesn't violate federal law, does not erase all of the language that comes before that, that suggests a prohibition of a program that helps institutions comply with federal law, anti-discrimination laws.
I guess I'm trying to differentiate between the fact that DEI are programs, federal law, the Civil Rights Act, the 13th, 14th, 15th, those are federal law, and so, but DEI is reference to programs and their initiation, so I just didn't see how removing those could be a violation of federal law, but I understand where you're coming from.
Because the DEI programs are sometimes to assist and facilitate the compliance with those federal laws.
I understand there may be programs in furtherance of that or an encouragement of that, but to remove them cannot be a violation of federal law.
No, this doesn't say that removing them itself on its own is a violation. It is clarifying that having those programs is not itself a violation, which again was stated in this hearing earlier. So that is that making it clear?
I don't think we're communicating real well, but that's great. I appreciate you.
If I could attempt one more time, Senator King. What was stated earlier is when institutions have diversity, equity, and inclusion programs, that is contradictory to the Civil Rights Act. That is what was stated here earlier today, and that it was described as another form of discrimination. What the Department of Education Office for Civil Rights is telling you in this document is that the existence of DEI and other programs, there are several other examples, this is not limited to just DEI programs. The existence and implementation of those programs, one, does not violate Title VI of the Civil Rights Act, and two, is often put in place to assist, facilitate compliance with laws that are banning discrimination on the basis of race, sex, and other protected classes. So these things work together to, again, remediate what has been historical discrimination. And I like to be careful with use of historical because, again, this has been during our lifetime. It's not, you know, just our ancestors' generations, you know, times of discrimination. These are times that I'm sure you all can recall in your lifetime as well, and that many people in this audience can attest to. So these programs are to address those issues, and that kind of gets to what we were talking about earlier. We're not all starting from the same point, and that is the importance of these programs, is to acknowledge that and remediate that.